Hello everyone, this is a criminal procedure topic, Double Jeopardy Basics, and it's linked to Chapter 4, Part A2 of the Miller and Wright text. Our guide through these rings of hell will be Stevie Ray Vaughan and Double Trouble. Not that they'll be singing along with us, but they'll just be here visually to help us through the material. It's complicated stuff, so we're only covering the basics here, and then there will be follow-up topics later. As you think about the charging behavior of prosecutors, you need to account for what I call the grouping rules. They come from different levels of law. So the limits may come from double jeopardy provisions of federal and state constitutions. These grouping rules sometimes take the form of joinder statutes or rules of criminal procedure that call for joinder of charges. These can be both permissive and mandatory joinder. And then there are internal office policies or departmental policies of prosecutors themselves that relate to re-prosecution after an initial prosecution. Together, these rules tell prosecutors the minimum and the maximum number of related charges that they have to pursue in a single proceeding. If the prosecutor fails to group related charges correctly, then it may be impossible later on to include those charges in some later proceeding. So when the train is leaving the station, which cars have to be attached to that train? That's what these rules address. So let's begin at the constitutional level. There are double jeopardy provisions in both the federal constitution and equivalent language in state constitutions. The idea here is that you cannot prosecute someone twice for the same offense. That's the key language. It's a common sense insight that once the government has assembled its proof and puts you through a trial, if there is no conviction, if there's an acquittal, then it would be quite oppressive if government could come back again and improve its evidence and learn from its mistakes the first time around and keep trying until they finally convince some jury along the way to convict you. So the basic idea here is that the government gets one clear shot at you and then they're done. The Supreme Court has described in a little bit more detail what the Double Jeopardy Clause prohibits. And so the court has said over time that there are three protections built into the Double Jeopardy Clause. First of all, you can't have a second prosecution after an initial acquittal. You also can't have a second prosecution after an initial conviction. If you want to say, try to double the sentence and get a conviction for the crime one time around, you get a 10-year sentence, and then get another conviction for the same crime and get another 10-year sentence or even a longer one. You can't do that. No second prosecutions after convictions for the same offense. And then finally, no multiple punishments for the same offense within the same proceeding. So if it turns out that the charges may have different names, but they're essentially punishing the same thing and the government's just stacking up charges, within certain limits, that is not allowed under the Double Jeopardy Clause, although as we'll see that it has been, that particular multiple punishment prong has been interpreted rather narrowly. So if the basic idea is that the government gets one clean shot at a defendant, when has the trigger been pulled? By the way, this guy here comes from an old 1970s thriller novel and movie, The Day of the Jackal. He's getting his one clean shot at Charles de Gaulle. At any rate, the case law talks about when double jeopardy attaches. And so we say that we have, the government has pulled the trigger. It has really taken its shot at a defendant once the jury is sworn for jury trials or once the first witness is sworn in for a bench trial in front of a judge. Or if we're talking about a guilty plea, then the Double Jeopardy Clause attaches when the court accepts that guilty plea. So once double jeopardy attaches, the general rule is that the government doesn't get to try you again for that same offense in some later proceeding. Once that trial begins, that's the government's only shot at you. Now, there are some exceptions to that general rule. So first of all, if there is a mistrial, if something goes wrong, and if it is an adequate reason to call off the trial, then the judge can declare a mistrial, and the government does get to try that defendant again. You could think of that as the trigger's pulled, but the gun jams. That doesn't count as a clean shot. But it's not a mistrial just for any reason. Later on, an appellate court will have to evaluate the adequacy of the reason, and will have to decide, was there a, quote, manifest necessity for the mistrial? So what counts as manifest necessity for a mistrial? Well, it's not just that the government witnesses weren't quite at their best, they had coughing fits, they could have been better, we'll declare a mistrial and try it again tomorrow. It's got to be something bigger than that, something typically unforeseen. There's a large common law of manifest necessity, and it's hard to generalize about it, but basically you're looking for something that is typically not deliberately brought on by the government in a very general sense. There's a second exception to the one clean shot rule, and that is if the defendant appeals a conviction. So let's say you got a trial, the government gets a conviction, and the defendant appeals on legal grounds and says, you know, the judge let in evidence that she shouldn't have, or something else went wrong at the trial, and therefore it was an illegitimate conviction. In that setting, we say the first shot never actually happened, and so we will roll the tape back in time, treat it as if the shot had never been fired, and we'll try again, but this time asking the government to follow the rules properly, or having the judge make the proper rulings on the legal questions. So you can have a retrial after appeal, and that's considered just an extension of the first trial. It's all just one shot. So remember, under the double jeopardy clause, the government can only prosecute you one time for the same offense. Notice the colonial era spelling here. So over time, the Supreme Court has asked the question, what counts as the same offense? Now you might say, well, just look in the code, and if the original prosecution was under Section 17, and this next one is also under Section 17, then it's the same offense. But the court has said, we're going to go more broadly than that. It's not just literally the same section. It may be that there are different sections in the criminal code that, in essence, charge the same crime. And so we won't depend literally on the code section numbering. Instead, we'll be asking about the elements of the offense. Now, the standard test for the definition of the same offense is the Blockburger test. Blockburger is sometimes also called the same elements test. And the court here looks at the elements of the crime, looking at it through a combination of what's in the statute books, what's in the pleading documents such as the indictment, and what the proof actually said at trial. And looking at that totality of circumstances in the proceedings, the court asks whether each provision each criminal provision requires proof of an additional fact which the other does not. And we'll apply that in just a minute. But that's the Blockburger test. Now, the Blockburger test is not the only possible test. There are some states that follow other tests to define what counts as the same offense, and your book discusses some of those. There was a brief period in the federal system where there was an add-on test. So under Grady versus Corbin, a 1990 case, the court said that at least when it comes to multiple trial cases, not the multiple punishment situations, but the multiple prosecution situations, In that setting, you would start with Blockburger, but you would also add a same conduct limitations. That is, you would prevent the government from bringing a second trial if maybe the Blockburger test wasn't met, but the two different charges came out of what was essentially the same conduct. But then 3 years later, United States versus Dixon overturned Grady versus Corbin, and so at the federal level, we returned strictly to the Blockburger test. But as I mentioned, some states still use some slightly different tests. They may not use the same elements test like Blockburger. They may use something like the same conduct or same transaction. In applying Blockburger, it may help you to think visually here. So imagine, first of all, crime A, and it has 4 elements. And so you have to prove element 1 and element 2. And then you also have to prove element 3 and element 4, all within the bounds of our beige crime A. And then let's say that later on there is a trial for crime B, and it all happened on the same date, and it arises out of basically the same set of facts, but it's a slightly different crime. It's not, listed as crime A. It's got a different name. It's a different section number in the code. And under this crime, also 4 elements you have to prove. And so you might prove element number 1 and element number 2. Notice these are the same things that the government had to prove as elements 3 and 4 in its earlier trial for crime A. It's in the overlap area between crime A and crime B. But then there are also elements 3 and 4 for crime B that are not in the overlap area. If you have crimes like this, where the government is proving some elements that may be in common between the two crimes, but then each crime has at least one element outside the overlap area. There's at least one element for crime A out here, and there's at least one element for crime B out here. Nothing in the overlap area. Both of them have at least something outside the overlap area. Then under Blockburger, that's not considered, quote, the same offense, and the government can indeed have 2 different prosecutions for those crimes, or could charge them both in the same proceeding and get multiple punishments for them. Now let's compare that situation to another pair of crimes, crimes C and D. Let's imagine that with crime C, you have to prove element 1 and element 2, and then maybe element 3. But then the government decides, all right, we want to bring another charge later on based on the thing that happened on that Thursday night. But we're going to call it something different. It's not crime C. We'll look for another section of the criminal code that may apply here. And so now we're going to call it crime D. And to prove this charge, we have to prove element 1 and element 2 and element 3. In this situation, if element 1 that was part of crime D is the same thing as what the government had to prove as part of crime C, I think we called it element 3 of crime C, and crime D still stays within this area of overlap. Everything that you are proving for crime D would also be an element for crime C. Then in that situation, what we have is crime D being a lesser included offense for crime C. And the court would say under Blockburger, yeah, those are the, quote, the same offense, even though they are not literally the same sections in the code. They have 2 different labels. One has different elements from the other. Nevertheless, one is a subset of the other. And so if you've got a subset situation like that, then you've got a violation of Blockburger and you can't have multiple prosecutions. So that should get us started for the basics of double jeopardy. We'll be talking a bit about how these concepts apply. In particular, we'll be practicing with the Blockburger test and looking in a little more detail at the competing tests for what counts as the same offense. So on we go.